you're going through a separation and someone told you that you can just agree to leave superannuation out of your property, they are wrong. Look, I get it. You're already dealing with enough stress trying to divide the house, sort out the kids, and figure out who keeps what. The last thing you want is another complication. Super feels like this distant thing you can't even touch for decades, so why not just leave it alone and keep things simple? I'm John Boy from JB Solicitors. I've been working in family law for over 17 years, handling everything from straightforward separations to complex international disputes involving trust, companies, and multi-million-dollar asset pools. Over the next few minutes, I'm going to show you exactly what a property settlement actually is and why super sits at the heart of it. Then I'll explain the 3 ways the law allows you to deal with super properly. And finally, the exact steps you need to take to protect yourself. Before we talk about super specifically, let me explain what a property settlement entails. Think of a property settlement like this. It's the legal process of dividing everything you and your partner accumulated during your relationship. And I mean everything. The house, the cars, savings, investments, businesses, and yes, superannuation. The Family Law Act doesn't just look at physical assets you can touch, it looks at all financial resources. That includes super, even though you can't access it yet. So even if you agree to leave it out and sign an agreement, that agreement could be set aside later because it failed to deal with a mandatory consideration properly. Think of it like this. Imagine you're dividing a cake, but you've agreed to pretend one whole layer doesn't exist. The law says you can't do that. You have to acknowledge every layer, even if you ultimately decide to leave one person with that particular layer. Now let me show you why this matters. Let's say partner A has $500,000 in super, partner B has $50,000. That's a $450,000 gap. If you exclude super from your settlement and just divide the other assets 50-50, partner B walks away potentially hundreds of thousands of dollars less than they are entitled to. And here's the thing, super is often the second largest asset in a relationship after the family home. I had a case recently where the husband had accumulated $680,000 in super over 25-year marriage, while the wife had taken time off to raise 3 children and had only $90,000. When we included super in the settlement, she received an additional $200,000 in value through a super split. That's life-changing money for retirement. The law recognizes the super accumulated during a marriage is a product of both parties' contributions, whether financial or non-financial, like caring for children or supporting a carer. So now that you understand why super must be included, let me show you 3 legitimate ways to deal with it. Option 1, superannuation splitting. This is where you actually transfer super from one person's account to another. It's not cash, the money stays locked in super, but the ownership changes. This works best when there's a big imbalance in super balances. For example, if one partner has $500,000 in super and the other has $100,000, you might split $150,000 from the high balance to even things out. The person receiving the split still can't access it until retirement age, but it's now in their name, under their control, and growing in their chosen fund. The benefit here is that it's clean. Each person walks away with their entitlement in their own super account. Option 2, offsetting against other assets. Sometimes it makes more sense to leave the super accounts untouched, but factor their value into the overall settlement. Here's how it works. If you have $400,000 more than your partner, they might receive a large share of the house or other assets to balance it out. I often see this with older clients, where one person is close to retirement. Rather than complicate things with a super split, we adjust the division of assets to account for the super imbalance. For example, instead of selling the house and splitting it 50-50, partner A might keep their largest super balance while partner B gets 70% of the house equity. The overall outcome is still fair. It's just structured differently. The challenge with offsetting is that you're comparing apples and oranges. Super is locked away while a house is accessible now. So you need to factor in that difference in timing and also in liquidity. Option 3, flagging. This is the option most people don't know about, and it can be particularly useful in certain situations. Flagging is where you acknowledge the super is your settlement, but defer dealing with it until later. You might flag it now, but agree to split it when one person actually retires and starts drawing benefits. This works well when the super is in a complex fund where splitting immediately would be complicated, costly, or result in a loss of benefits. For example, some public service super schemes have specific rules about when and how they can be split. Flagging allows you to lock in the agreement now while deferring the actual split until it makes practical sense. Now you might be thinking, this all sounds important, but where do I even start? What do I actually need to do right now to protect myself? If you are currently separating or recently separated, here's your step-by-step action plan. Step 1, get the information. You need current statements for all super accounts, both yours and your partner's. Most funds will provide this if you request it directly. For some funds, particularly government schemes, you may need to complete specific information request forms. Step 2, get a proper valuation. Some super interests are straightforward to value. If you've got a standard accumulation fund, the balance on your statement is usually sufficient. But others, particularly defined benefit schemes like certain government or corporate funds, require specialist actuarial calculation. If either of you has a defined benefit fund, you'll need a specialist valuation. Step 3, consider your options. Based on the balances, your ages, and your assets, you need to decide whether splitting, offsetting, or flagging makes the most sense for your situation. This is where you should get legal and financial advice. Every situation is different. What works for one couple might be completely wrong for another. Step 4, formalize it properly. Whether you decide it needs to be documented correctly through consent orders or a binding financial agreement. Let me break down what each of these mean. Consent orders are court orders that you and your partner agree on and submit to the family court for approval. The court reviews them to ensure they are just and equitable, and once approved, they become legally binding orders. The benefit is they are final. Neither party can come back later and make another claim against your super or property. You get certainty and protection. To get consent orders, you'll need to prepare an application for consent orders, attach your proposed orders, and include supporting documentation showing your assets, liabilities, and super interests. Binding financial agreements, often called BFAs or prenups if done before marriage, are private contracts between you and your ex-partner. They don't require approval, but they must meet strict legal requirements to be valid. Both parties need independent legal advice, and the agreement must be properly drafted, signed, and witnessed. If these requirements aren't met, the agreement can be set aside, leaving you unprotected. Superannuation might feel like a distant asset, but it's real money that will matter enormously when you reach retirement. Don't let short-term convenience cost you long-term security. Deal with it now properly, and you'll thank yourself later. If you need help navigating your property settlement, including super, book a consultation with our team. The link is in the description below. Thanks for watching.